At the conclusion of this lecture, you will be able to analyze the effect of a company's constitutional documents, describe the contents of model articles of association, understand how articles of association can be changed, and understand the controls over the names that companies may or may not use. In the previous presentation, we dealt with the documents required before a company can be incorporated. The core documents are the Memorandum of Association and Articles of Association, with both essentially being documents explaining the purpose and layout of the company to the public at large. They are made public in the aim of attracting maximum investors and for ensuring that no illegality is taking place by the company. As already stated, the Memorandum of Association relates to the external affairs of the company, whereas the Articles of Association relates to the internal affairs of the company. The Company Regulations of 2008 are the default company constitution for limited companies under UK company law. The model articles will apply to a limited company if it does not register its own articles, or, if it does register them, they will apply to the extent that they are not modified by the articles of the company. There are no model articles for unlimited companies, as these types of companies are relatively rare and often have very specific needs that do not justify a standardized approach. Schedule 1 contains the model articles for companies limited by shares. Schedule 2 contains model articles for companies limited by guarantee, which are often non-profit. Ordinary commercial companies registered under the new Act will have articles based on the new model articles. They set out the rules for running the company and are a contract between the company and its shareholders because they contain the shareholders' rights in the company. Standard Articles of Association. Most companies are set up using standard documents belonging to the company registration agents or solicitors undertaking the formation. Such documents are based on the new Model Articles, a government-approved standard document. They work perfectly well for a single-person company. We will now turn towards the contents of the Model Articles. Articles Provisions on Share Classes. Most companies have just £1 ordinary shares. There can be many reasons for creating different classes of shares, including for tax reasons, such as when special shares are created for employees or members of the shareholders' families. Articles Provisions on Share Allotments. Different arrangements suit different companies, such as giving the directors maximum freedom over share allotments so they can allot shares to anyone they wish. Articles Provisions on Share Transfers. The model articles give the Board of Directors an absolute discretion to refuse to register any share transfer, but other common alternatives are preemption provisions on any transfer, so that shares have to be offered to existing shareholders before they can be sold to anybody else, or that all shareholders must consent to any transfer, or special transfer provisions, for example, that shares can be passed to members of a shareholder's family, or that some classes of shares are treated differently from others. Articles Provisions on General Meetings. Where the most important decisions are made. Most decisions are made by passing an ordinary resolution, which requires just a simple majority of those who vote. Some decisions, for example, to alter the articles, require a special resolution, which has to be passed by a 3/4 majority of those who vote. At this meeting, each shareholder has the number of votes conferred by the shares they hold, usually 1 vote per share. Article Provisions on Board Meetings. Board meetings comprise of the directors of the company. The board has control of the day-to-day running of the company, including all commercial decisions. At a board meeting, unless the articles say to the contrary, every director has 1 vote. Articles Provisions on Directors' Appointment, Resignation, and Removal. The model articles provisions on the appointment of directors are that the board or the general meeting can at any time appoint an additional director. As to the removal of directors, it is that any director can be removed by an ordinary resolution of the members. The model articles also provide for automatic ending of office in certain circumstances, for example, where a director becomes bankrupt or disqualified from acting. The Companies Act states that the amendment or repeal of any provision in the articles requires a special resolution of members. A company is free to incorporate under different articles of association or to amend its articles of association at any time by a special resolution of its shareholders, provided that they meet the requirements and restrictions of the Companies Acts. Such requirements tend to be more onerous for the public companies than for the private ones. In business or commercial law, special resolution is a resolution passed by the shareholders of a company by a greater majority than is required to pass an ordinary resolution. The precise figures vary in different countries, but commonly an extraordinary resolution must be affirmed by no less than 75% of members casting votes, whereas an ordinary resolution requires only a bare majority. Subject to the provisions of this Act, and to the conditions contained in its memorandum by special resolution, a company may alter its articles. However, it must be provided that no alteration made in the article under this subsection, which has the effect of converting a public company into a private company, shall have effect unless such alteration has been approved by the central government. Where a company has passed a resolution to amend or repeal its articles, that resolution will take effect on the day it is passed or on a later date specified in the resolution. Where any alteration, such as is referred to in the proviso to subsection 1, has been approved by the central government, a printed copy of the articles as altered shall be filed by the company with the registrar within 1 month of the date of receipt of the order of approval. A private company is also prohibited from altering its articles if the alteration is inconsistent with the requirements of Section 12 of the Companies Act 2006. The alteration of a company's articles is also subject to some limitation on the member's voting power. The member must vote in the best interests of the company as a whole. Although a member may exercise his votes freely, it must not result in the oppression of other members or be tainted with malfide. The court will not interfere in the freedom of voting of the shareholders, unless unreasonable decisions are made. Amendments must not conflict with Companies Act example directors, removable only by special resolution. Amendments must not be illegal. They must not deprive members of statutory protection, force members to take or subscribe for more shares, or increase liability to contribute without written consent. Be an abuse of majority power. Registered companies have the statutory right to alter their articles at any time by special resolution and cannot contractually restrict themselves from exercising this statutory right. The name that can be given to a limited company is subject to certain restrictions, controls, and requirements, as set out in the Company and Business Names Regulations 2009 and governed by the Companies Act of 2006. These rules are in place to uphold legal and social standards by maintaining fair business practice and preventing any offence or confusion being caused to the general public. It will be necessary to carry out a number of checks prior to registering with Companies House to ensure the name you have chosen will be permitted. The main restrictions and requirements outlined by Companies House are as follows. The name must not be the same as or too like an existing name on the index of company names, unless your company will be part of the same group as the existing company. Private limited company names must end with Limited or Ltd. Certain characters, signs, symbols, and punctuation will not be permitted. Names cannot suggest a connection with HM government, a devolved government or administration, or a specified public authority. Permission is required if the name includes any sensitive words or expressions set out in the regulations. The name should not be offensive or include offensive words. Turning towards the issue of choosing a name, it is advisable to check potential companies' names with the Companies House web check facility. Both of these will tell you if the name is already in use or closely matches an existing company name. It is also advisable to check the name against the trademarks register to ensure the name will not step on anyone's trademark toes. If the proposed name contains any sensitive words, you will be required to seek permission from the relevant authority. If permission is granted, Companies House must be given the supporting documentation when you submit your application to register your company. In conclusion, the Memorandum and Articles of Association are the constitutional documents of a company. The Company's Model Articles Regulations 2008 established model articles of association which must be followed by companies. An ordinary resolution is passed by a simple majority. Special resolution is passed by majority of around 75%. Changing of the articles requires special resolution. A company has certain restrictions to follow in naming itself.